Let's talk about settlement agreements or compromise agreements or termination agreements. These are the type of agreement that I come across very, very frequently when an employee is terminated from work. There may be a redundancy situation, there may be some sort of a dispute, there may be other reasons as to why essentially the termination of employment is going to happen, but the employer and the employee recognise that it might be the best thing for both parties if they enter into some sort of an agreement. Now, the agreement can be called a termination agreement, a settlement agreement, an exit agreement. Call it what you like, it amounts to the same thing. And the thrust of it is this: the employee will be paid a certain amount of money by the employer, generally called a termination payment or a settlement payment or an ex gratia payment or something of that nature. In return for that, the employer is going to want the employee to enter into this agreement. And the money shot in the settlement agreement from the employer's perspective, remember, the employer is not giving away money for the good of his health. The money shot for the employer is that the employee waives his or her right to bring any claims against the employer arising from the employment situation. So it's a very, very straightforward quid pro quo. The employer gets peace of mind and gets comfort from the termination of an employment contract, knowing that no claims can come down the tracks. In return for that peace of mind, he or she is paying the employee a certain sum of money. And obviously the employee then is getting this money, and it's a question of negotiation as to how much he or she manages to get. But the payoff for the employee then is obviously obvious. They get the money. That is the deal with the devil, as it were. That is the purport or the significance of a settlement or compromise or exit package or agreement. Now, in addition to that, there's going to be other standard enough clauses in the agreement, and they will include perhaps non-disparagement. In other words, both parties will agree not to badmouth the other party, confidentiality, jurisdiction, various boilerplate clauses, perhaps even a reference or perhaps a statement of employment. The employee obviously would be looking for a reference. The employer may say we have a policy of statement of employment only, and that again is negotiable. But the significance is, the quid pro quo is, the employer gets peace of mind that no claims can come down the track, and the employee gets the few bob. Now, the significant thing is that the employee must be encouraged, and indeed I would say it should be insisted by the employer that the employee gets independent legal advice in relation to the agreement, in relation to the terms of the agreement and the meaning and significance of those terms. And it's in the employer's interest to have a letter or an invoice or both from an external solicitor, which the employer will pay, which will give the employer the protection of being able to show that the employee had independent legal advice and cannot come back for another bite of the cherry by saying I was under duress or I didn't know what I was doing or anything of that nature. Now, it does happen from time to time, and I have a case coming up in the not too distant future of an employee signing such an agreement. And in the particular case I'm involved in, we're bringing a claim against the employer because the employee did not have independent legal advice, didn't have any legal advice at all, didn't have the assistance of a trade union person, and was, we will say, coerced and put under duress to sign this agreement, which was clearly not in the employee's interest. That's another day's work. That's a case that's coming down the tracks. I'm looking forward to that. However, I've written a blog post there now in the last few days. It's on employmentrightsireland.com, and it deals with a WRC case where there was an employee working for, I think, an agency or perhaps an employment agency of the HSE, there was a dispute, or there was a discussion and a consultation process and so on, or some sort of a process in relation to redundancy. The employee then felt that she needed the ex gratia payment. She didn't get legal advice. She didn't have the assistance of a union. She signed the agreement, and then later on she brought a claim to the WRC for unfair dismissal. I've written a blog post about it, but the WRC decision then goes into the various cases, one of which, or the most important of which, is probably Hurley versus Royal Yacht Club, but goes into the cases which look at this question of what is a valid or informed consent by the employee. How far does the employer have to go in terms of ensuring that the employee gets independent legal advice? Does the employer have to insist on that, or is it enough to say, you've had the opportunity to get independent legal advice, please sign here and we'll give you the cheque? In this particular case, the question of informed consent is key, and the Employment Appeals Tribunal has held in the past that the informed consent requirement would not be met merely by the statement in an agreement that she was given the opportunity to take independent legal advice. That's not enough, according to the Employment Appeals Tribunal, and that's probably a line of reasoning, or a line of jurisprudence, as it were, that WRC will find, or will follow as well. So if you're an employer, you need to be very careful that you really do insist that the employee gets independent legal advice, and that you pay for it, quite frankly, because that is your guarantee that the employee cannot come back and have another bite of the cherry. If you're an employee, obviously, if you have been forced or coerced into some sort of an agreement, you were unsure of what you were signing, you were unsure of what rights and to what extent, or how extensive the rights were that you were signing away and waiving and so on. If you were unsure about that stuff and you were put under pressure and you needed money, and perhaps there may even have been a psychological or a medical reason as to why you at that particular point in time could not give informed consent, well then you may well be able to come and have another bite of the cherry and bring a claim against the employer for, unfair selection for redundancy, or for unfair dismissal, or whatever. Now, in this particular case of the WRC, it goes into the various features which must be present when informed consent is given, and when a settlement agreement will be binding and the employee cannot come back. The argument, obviously, in this case was that the employer was saying that, look, the employee has signed this agreement, and you, jurisdiction, or you, the WRC, do not have jurisdiction to hear this case, because this termination was brought to an end by way of a settlement agreement and both parties have signed it. As it happens, the adjudicator in this particular case held that the employee did not have or did not give informed consent and did not have the benefit of independent legal advice. Having found in her favour on that particular head, the adjudicator then went on to hold that the redundancy, in fact, even though it wasn't carried out in a perfect fashion, was fair. So it wasn't an unfair dismissal. It's an interesting case, though. It's simply a case, again, that looks at this question of settlement or compromise agreements, and it's one that is worth having a look at. It's on my website, employmentrightsireland.com, and the name of the blog post is Employee Claims Compromise Agreement Not Binding on Her Because No Independent Legal Advice. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.